Parliamentarians who are to be loyal to Parliament rather than to the Supreme Court run to the Supreme Court at the slightest opportunity to use the Supreme Court to undermine Parliament. This might be one of the reasons Parliament and members of Parliament are not respected and treated with disdain. This was exhibited by the President's refusal to even receive the LGBTQ+ bill, duly processed and passed by Parliament without any legal basis. The judiciary is supportive of this conduct by the receipt and processing of a suit on this subject matter. These are dangerous precedents in our democratic journey. Both the President and the judiciary have sinned against the Constitution and must seek the opportunity to confess and repent to be forgiven. If I may ask, is it a legal matter for the Supreme Court to decide as to which side of the House constitutes the majority or minority? It is for good reason that justice is said to be blind. And further, that justice must not only be done, but must be seen to be done in all cases, not in only those cases to which some people appear to be sentimentally attached. Fellow Ghanaians, I respectfully call on the Supreme Court to apply the same swiftness with which the motion ex parte in the instant matter was granted to the case involving the President's refusal to receive the Human Rights and Family Values Bill passed by Parliament, which has been pending before the same court for almost a year without being heard. Ladies and gentlemen, consistency is not just an ideal, but the foundation of life. The court cannot enjoin 4 members of Parliament from serving their constituents for 12 weeks, but was very eager to deny the constituents of Assin North their representation because of the issue of allegiance. The court cannot deny the constituents of Sal the sanctity of representation for years. The court cannot even see that the Constitution itself permits a denial of representation within 3 months to the holding of a general election. It's in the Constitution. Ladies and gentlemen, the Parliament of Ghana shall commence sitting as by law prescribed from tomorrow, November 7th. We have a possibility of a minority government where the voters vote for the President, but he has less members of Parliament, and that is a minority government. How is he going to get the majority members of Parliament to always approve his business for him to govern the nation? We can also have a coalition or a merger of parties government. And the familiar one we know is the majority government. These are possible governments constitutionally guaranteed in Ghana. In the current hung Parliament, the new standing orders of Parliament had to cater for such a government by a number of provisions in the standing orders. We also provided provisions for all the other options of government that I just explained. For instance, a day which we called a decision day has been designated in the new standing orders, where the Speaker, in consultation with the leadership of the House, will set aside to allow members of Parliament who are ministers and deputy ministers the opportunity to be present in Parliament to be counted in support of government position to ensure government business does not suffer for lack of government members of Parliament in Parliament. Despite the above, often the number of government members present still don't add up due to the nature of the duties and responsibilities of ministers and deputy ministers. The NDC members of Parliament, however, understood the situation and on a daily basis cooperated with the MPP members of Parliament to see government business through. In spite of this, the NDC members are said to be saboteurs of government business by the MPP members of Parliament and the followers of the new patriotic party. Those of you who cover proceedings on a daily basis are witnesses as to how sometimes I have looked at the members of the NDC in a very stern manner, which made them give in to their objections, just to get government business going. Ladies and gentlemen, the powers of the judiciary ends where the nose of Parliament starts. The Constitution is very clear on freedom of speech and of proceedings of Parliament. Articles 115 and 116 grant members of Parliament privileges and immunities of speech, debates, and proceedings on any matter or thing brought by a member in or before Parliament by petition, bill, motion, or otherwise. And I want to quote the two articles to you. Article 115. There shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. Article 116. Subject to the provisions of this article, but without prejudice to the general effect of Article 115 of this Constitution, civil or criminal proceedings shall not be initiated against a member of Parliament in any court or place out of Parliament for any matter or thing brought by him in or before Parliament by petition, bill, motion, or otherwise. This means happenings in Parliament must remain in Parliament.